Good morning. My name is Lionel Bentley. I'm a law professor at the University of Cambridge, and I've been asked to share some insights on what's been happening in the world of copyright. So let me begin. Struggling, sorry, to move these slides on. Sorry, I've got the Zoom screen. I can't seem to. Oh. Okay, I hope that's working for you. So there are four topics that I'd like to discuss today. Firstly, I'd like to say something about copyright works and where we are after the Retained EU Law Act 2023. Then I'd like to say something about originality, looking at the test of author's own intellectual creation and some experiences in the English courts with the author's own intellectual creation test. Then I'd like to say something briefly about infringement and a case concerning style. And then finally, I'd like to wrap up with a few comments on the decision of the High Court that came out yesterday in the AI case, Getty and Stability AI. So with regard to works, I don't know whether the implications of Ruler have been clearly appreciated or are indeed all that clear. The background is that the UK protects copyright by way of a closed list, a list of identifiable subject matter specified in sections 1 to 8 of the CDPA. If something doesn't fall in that list, then in principle, it wouldn't be protected by copyright. However, the CJEU, the Court of Justice of the European Union, recognised that works should be protected if they were expression that reflected the author's own intellectual creation, thus embracing an open list and rendering a tension between UK law as understood before harmonisation and the harmonised law. Now, until the end of 2023, when Ruler came into force, a principle of EU law known as the Marleasing principle, derived from the principle of the supremacy of EU law, was assumed to apply. And that meant that British law would have to be interpreted in line with EU law. So in the case of Shazam versus Only Fools and Horses Dining Experience, the Deputy Judge John Kimball QC said that there were two stages to ascertaining whether work would be protected. First, you ask whether it's required to be protected under EU law. So is it expression that reflects its author's own intellectual creation? And secondly, if it is, can it be fitted into the words in section 1 to 8? And in that case, he held that a character from the television show Only Fools and Horses was a work within the EU conception and could be fitted in the words of section 1 to 8 because it could be treated as a literary work. And in subsequent cases, the courts have done similar things. So in Response Clothing, His Honour Judge Richard Hakon in the IPEC adopted a broad interpretation of works of artistic craftsmanship derived from New Zealand law, the case of Bonds and Cook, to accommodate a particular wave design of fabric and held it therefore to be a work of artistic craftsmanship. But in Water Rower, about which you'll hear more later, not from me, in the session on designs, Judge Campbell Forsyth declined to give a broad interpretation of works of artistic craftsmanship in relation to the Water Rower rowing machine, saying to do so would go against the grain. And under the Marleasing principle, you only needed to interpret UK law in line with EU law if it was possible. And if doing so went against the grain, you just had to stick to basically the UK law. So this is the position before ruler. With ruler, Mar leasing no longer applies. And we're supposed to go back to giving sections 1 to 8 their normal interpretation. However, where provisions count as assimilated law, then it is necessary for courts of the first instance, and most likely also appellate courts will decide to do so, to follow the CJEU case law. If there are provisions such as the provisions like on computer programs and databases, then those are clearly provisions of assimilated law reflecting the implementation of the Computer Programs Directive and the Database Directive. And you need to follow CJEU case law unless an appellate court decides to deviate. But the matter is much more complicated with regards to the other provisions in section 1 to 8, which may or may not be regarded as assimilated law. So let's look at an example. The Stormtrooper helmet from the Star Wars films. If a work is created before the 31st of December 2023, the date from which ruler applies, then you have to continue to apply Mar leasing. And so if you were interpreting the word sculpture in the closed lists of works, you would have to interpret it to give effect to Lavola Hengelo and the COFEML decisions of the CJEU. And that would mean that if you had a three-dimensional work that was an original expression, it ought to be protected. So prior to 2023, seems to me the Stormtrooper helmet would be regarded as three-dimensional expression and therefore ought to be regarded as falling within this broad interpretation of the word sculpture and thus to be protected. And these would have been acquired rights, so could not be taken away by the change in the law that the ruler effected. However, if the Stormtrooper helmet was created after the 31st of December 2023, we go back to interpreting sculpture in the normal way, and thus we apply the Supreme Court decision in Lucasfilm and Ainsworth, which had held that this Stormtrooper helmet was not, in fact, a sculpture under British law. So we have a very odd situation in relation to works that we need to think about the meaning of works and whether something qualifies as a work, depending on whether it was created before the 31st of December 2023, when we might be applying a much broader interpretation, or after the 31st of December 2023, when we'll be applying only a normal interpretation. Okay, so that's a bit of a mess. Here's some more mess for you. So as you know, literary, dramatic, musical and artistic works will only be protected if they are original. And under British law, traditionally, the test was whether these were the products of labour, skill and judgment. But under EU law, the position changed. The Court of Justice decided that in relation to all works, the test of originality was whether the work was the author's own intellectual creation. And in THJ Systems and Sheridan, the Court of Appeal confirmed that that is now the test for originality under UK law. Now, under the CJEU case law, this requires four things. Firstly, there must be expression rather than merely facts or functional attributes. Secondly, that expression must be a result of free choices that aren't constrained by rules or functions. They must also be the expression of creative choices. And we now have some potential guidance on what counts as a creative choice from the Advocate General's opinion in the Mio and Connectra case. There, the Advocate General said that just because a choice is free didn't mean it was creative. So choices may be free but not creative if they are a result of purely utilitarian considerations, or they result from methods or standards that are commonly used, nor will they be creative if they are completely insignificant or banal. So we start to get some idea that not all choices count as relevant choices for the purposes of determining originality. And then we reach the fourth stage, which is also considered in Mio and Connectra, which is that the creative choices must be reflected in the work so as to stamp the imprint of the personality of the author on the work. That is, they must give the work something unique. Now, it seems to me that this elaboration of the 4 stages takes the originality standard quite some way from the old labour skill and judgment standard. However, the British courts, seemingly applying the test, have not really moved away from the labour skill and judgment standard. So UK courts, despite the holding in Sheridan, and even, in fact, in that case, seem only to be concerned with the first 2 stages, whether there is expression that reflects free choices. The courts may use the words creative choices and imprint of personality, but they pay only lip service to it. And we can see this in various cases: Liddell, Arger Rangemasters, Lant, and Courtney Smith. And I'm not going to talk about all of them, but let me just show you quickly what the subject matter was. So in the Sheridan case, the subject matter was that chart on the top left-hand corner of the screen. And the judge found that the Court of Appeal affirmed that there were creative choices in things like the layout of the chart and the choice of colours and fonts, etc. In the Arger Rangemaster case, at the bottom left of the screen, we were concerned with whether there was copyright in the dial on an Arger cooker. And the judge, Nicholas Caddick, sitting as the judge in the IPEC, found this dial to be original because the buttons could have been press buttons, but were instead rotational buttons. They were positioned one above the other. There was an oval circle drawn around, and a line was drawn from the oval circle across horizontally and then vertically up to a thermodial. And all those constituted, in the judge's view, creative choices such as to allow the author to stamp their personality on the work. In the Liddell case, in the Court of Appeal, Lord Justice Arnold confirmed that putting the choice of a blue square around a pre-existing red and yellow circles embodied sufficient choices to create an original work. There was the choice of the shape, square, the choice of the color, blue, the particular tone of blue, the positioning of the shape in relation to the circle, the distance from the edge of the square to the edge of the circle. And those constituted choices which the Court of Appeal thought were sufficient to give originality. In the Lant case, the lower Venom logo was regarded as original over and above the previous Venom logo that you can see pictured above. And perhaps most surprisingly to me, in the Notting Hill shopping bag case, that logo for the Notting Hill shopping bag was regarded as original, so that there were choices supposedly that were creative and reflected the author's personality in choosing not to capitalize the T, in choosing where to put the full stop after bag, in choosing the arrangements of the words so as to create an original work. So it strikes me that what we have in the English case law is a paying of lip service to the CJEU test and not really engagement with it or understanding of it. And that's something that it'll be interesting to see progress as we go forward. Will the labour skill and judgment test ever be relevant? Well, yes, the labour skill and judgment test does have relevance for rights, vested rights that were created before harmonisation. So computer programs created before 1993, photographs created before 1995, databases created before 1996, and other authorial works created before the 22nd of December 2002, which was the date of implementation of the Information Society Directive. Works that were already vested under British law before that time, applying the labour skill and judgment test, did not lose protection as a result of EU harmonisation. And this can be important, could be potentially important, because lots of authorial works in fact date from a considerable time ago. So, for example, the Venom logos in the Lantern plastic head case were created in the late 70s or early 1980s. And in principle, I would say that the court should have been applying the labour skill and judgment standard in that case anyway, rather than the author's own intellectual creation standard. But doing so on the holding would have made, in fact, no difference. I wanted to briefly mention AI because everybody loves mention of AI, and just to draw your attention to another strange possible consequence of the retained EU Law Act of 2023. So you will know that the 1988 Act purported to protect computer-generated works. And Section 178 defined computer-generated works as a work that's generated by a computer in circumstances such that there's no human author of the work. And Section 9.3 then went on to identify who should be taken to be the author, given that there was no human author. And other provisions of the Act made alterations as to the term and the rules relating to moral rights in relation to computer-generated works. Now, while British law was bound to follow EU law under the Marleasing principle, one problem with these provisions was that they could have no application. And they could have no application because they purported to apply to original literary, dramatic, musical, and artistic works. But the criterion of originality, as we've just seen, required expression of free and creative choices, such as to enable a person to stamp their personality on the work, and so presupposed the existence of a human author. So I think before the 31st of December 2023, these provisions would have to be regarded as OTOs. However, after the 31st of December 2023, the courts are required effectively to give effect to UK law, and UK law does not get overridden in any way by EU law. And so a UK court will now be, I think, feel obliged to give these provisions meaning, and therefore identify a test of originality that can be applied to computer-generated works. And we are as yet struggling to determine what that test of originality might be. It can't clearly be the CJEU's test of author's own intellectual creation. Could it be labour skill and judgment again? That strikes me as one possibility. The third topic I wanted to deal with was infringement. And I want to make a couple of preliminary points before moving on to look at a recent case concerning infringement by taking style. So you'll recall that in order to establish infringement, you need to demonstrate that one of the relevant rights in Section 16 is implicated, so reproduction, public performance, communication to the public, etc. That the defendant's work or material is derived from the claimant's work, and that the act that the defendant is doing is being done in relation to the work as a whole or any substantial part of it. And that's Section 16.3a of the CDPA. And that was, in terms, a different test from this test in the EU law, which referred to any part rather than any substantial part. And the Court of Justice had indicated in the InfoPack case that any part meant any part that contained or reflected the author's own intellectual creation. So it really meant any original part of the work. Now, the UK courts followed the InfoPack decision and continue to do so, so that substantiality is understood, even in the post-ruler context, as any part which is original to the claimant's work. But there may be some situations where the court will have to deviate from that test of substantiality. And one example might be where the works are original as a result of labour's skill and judgment from the pre-harmonisation era. And we can see that in the IDD, QD and Codebury decision, which related to a database of postcode addresses that had been developed by the Royal Mail since the 1950s. And the High Court held that in relation to pre-harmonisation databases, the originality test was labour skill and judgment for conferring copyright on pre-harmonisation databases. And thus the test of substantiality also should reflect that. And the court should therefore look for whether the defendants had used a substantial part in the sense of a part that incorporated the labour skill and judgment of the creators. The recent case that I wanted to talk to you briefly about is the Chantelle case. And this concerned an artist who does wall paintings. And this is the wall painting concerned on a wall in a museum in North America. And you can see Chantelle Martin uses line drawing with the appearance of something like a marker pen. And the line drawings comprise landscapes and faces and birds, etc., and are in many ways, I think, what a trademark lawyer would say as quite distinctive. And in the case, Chantelle Martin and the copyright owner of her works brought proceedings against the importer of wine from Argentina on the basis that the labels on the wine bottles and boxes were infringements of the copyright. And so you can see again a smaller version of the Chantelle Martin wall painting there, and on the right, the one of the bottles in issue in which the wine had been imported. And you should be able to see immediately, I think, that there are some expressive features in the wine bottle on the right-hand side that map quite closely onto the Chantelle Martin drawing. So the head at the top left of the, just above the A of a Minga, you can see about a third of the way in from the right-hand side on the Chantelle Martin image, the ploughed field just to the right, just above the N and G of the bottle. You can see a corresponding ploughed field just to the right of the head that I just identified in the Chantelle Martin image. And if you go down below that, underneath the N and G, right down to just above the Malbec, you can see a tiered ploughed field image. And you can see that's corresponding tiered ploughed field image on the Chantelle Martin image as well. So in relation to that label, the judge, David Stone, sitting as judge in the IPEC, said there was no doubt in his mind that the first label is clearly a copy of the Chantelle Martin image. There are particular features of the work, some of which I've just highlighted, which are identically reproduced, and they're arranged in space identically. The first label is clearly a copy of part of the work. And he applied the InfoPack test. The first label has taken that which conferred originality on the copyright work or a substantial part of it. The defendants had also were also accused of infringing by reference to two other labels. And these were a bit different because they did not take any of the material in the Chantelle Martin image anywhere near so closely. So here's the second label on the right-hand side. And you can see that stylistically it's similar. There's line drawings, there's hills, there are ploughed fields, there are birds, etc. There are no faces here, as far as I can tell anyway. And the ploughed fields are not literal copies. There are some sort of similar images, but nothing that maps directly on. And here the judge found that there was no infringement. Rather, perhaps to state the obvious, he said, in a question of copyright infringement of an artistic work, it is what it looks like that matters. Comparing the two works side by side is key. It may help to observe that both the artistic work and the alleged infringing copy include birds, but that will not matter unless some element of the expression of the birds in the artistic work has been taken. Otherwise, the analysis falls foul of the principle that no copyright subsists in a general idea. And it was very much the same with the third label, which was very like this, or a similar position to the second label. And here the judge said where there are similarities, there are banal aspects of the language of drawing, such as lines, loops, dots, birds, and suns. They are not, and this is important, lines, loops, dots, birds, or suns as drawn by Ms. Martin in the work. They are not the expression of her creativity. And this just confirms then that there is no copyright in relation to style. Style can be a part and parcel of the expression, which if taken constitutes an infringement, but style in itself is not something that copyright protects. So finally, I wanted to mention the Getty Images and Stability AI decision, which came out from the High Court yesterday. And I mentioned this, I've only had a brief chance to look at it. There's quite a lot in there on trademark infringement on sections 10(1), 2, and 3 of the Trademark Act 1994, and some interesting comments on relation to what counts as use of a trademark. But the only thing I want to talk about is the copyright elements. So you will all probably know that this concerned Stability AI's a model, Stability Diffusion, which had been trained on a lot of works on the Leon dataset, amongst other things, which was drawn from the internet. But these clearly included many of Getty Images' copyright protected images. And indeed, it was shown and it was acknowledged that images had been produced by the Stability Diffusion model, which included Getty Images logo, hence the trademark issues that I mentioned before. The claim to copyright infringement by training on the material had been dropped. As it turned out, this had occurred outside the UK, and UK copyright law only applies in relation to infringing acts that occur within the United Kingdom. The training had been done almost certainly in the United States, and so that would be a matter of US law whether that constituted an infringement. There was also, importantly, no claim that the models themselves contained or stored the claimant's works. And although there was some evidence of so-called memorization, the evidence that the judge reviewed was against the idea that the models themselves stored the claimant's works. So the claim was limited to secondary infringement under Section 22 and 23 and Section 27 of the CDPA. The essence of the claim was that the defendants were importing the models into the UK, and in doing so were importing articles which, had they been made in the UK, would have constituted an infringement. And Mrs. Justice Joanna Smith found that the defendant had indeed been importing articles into the UK, but that these were not infringing copies. So she said the term articles included intangibles. So if there was an infringing copy, then there would be an article. This was because infringing copies in Section 17, or copies by reproduction in Section 17, includes reproduction by way of electronic storage. The terms copy and articles were intended to be general terms that were open to shifting understanding depending on new technological environments, and there was nothing, therefore, no reason to limit the notion of articles to tangible articles. So that was all in Getty's favour. But then, in favour of Stability AI, she said that these were not infringing copies. She said they would only be infringing copies if the article contained or stored, albeit only temporarily, a reproduction of the work. And since it was accepted that there had been no storage of Getty images on the Stable Diffusion models, then therefore they were and had never been infringing copies. In other words, Stability Diffusion's making of the articles involved use of infringing copies, the training data, but the making did not constitute an infringement so as to fall within section 27. Okay, so that's all I've got to say to you this morning, but I would be very happy to take any questions if you have any. Oh, no, I've got one more slide. The case, I suppose, importantly leaves open a few other issues. Firstly, it might still be possible, if the evidence supports it, to argue that a model does contain reproductions in whole or in part. And there's certainly an academic literature out there that supports that view. Secondly, there is still the possibility that proceedings could be brought in relation to outputs from AI systems, and it might be that the model developer is liable for those outputs, either as authorizing the outputs or as a joint tortfeasor with the person who produces the outputs, or perhaps being directly responsible for the outputs. And of course, the case says nothing about the issue of training, and it may well be that if you train a model in the UK, that there will be liability on that basis. Okay, now I've finished, and I'm happy to take questions. Thank you.